Professor Vivi Pandey touched the thing that what is happening in our society today due to change of technology and another our attitude to life, attitude to society, and also the legal norms. There are classical concept of criminal law that it will be specific. If we think of Sutherland, there should be politicality, specificity, universality, and sanction. But that limit is no longer we can control technology and also the social perception and cross-border offences, organized transnational crime. So the jurisdictional issue, the technological issue, all this and the investigation and punishment, all issues now having a demand of relook, reimaging. With that, we will pass here, I think, with 5 minutes speech fast, then we will give another round of reaction to other speech and open to. So our time is 1 hour, we try to complete it within 1 hour.
Sure, sir. Thank you so much, sir, for setting up the tone for the discussion. My first question is to Professor Sarfaraz, sir. Sir, the question is, does the excessive criminalization violates Article 21 of in the judgments given by Supreme Court of India? Because whenever we talk about over criminalization, we looked up to Article 21. Is it so, sir?
Okay, good afternoon, everyone, and thanks for organizing this program and inviting us. This is an important issue today, which we are going to discuss on over-criminalizations and linked with the Article 21. As we know, Article 21 consistently debated, and the court has held part of trial is a part of Article 21, right to speedy trial is a part of 21. If any circumstances when there is a excessive criminalization has been used, definitely person's right to hamper. Today, many circumstances when we say that under our system, the process itself become punishment. Those process is actually not a just, reasonable and fair procedure, as Maneka Gandhi has categorically laid. So any process which is unjust, any process which process is amounted to punishment, cannot be a just process under Article 21, and hence is the violative of Article 21. Many times this overbreadth of these criminalizations have a chilling effect, and we are starting saying that many circumstances when regulatory framework has been brought into the criminal law purview. Many things which are in civil nature, and in the law nowadays we are relying on the criminalizations. Just today I was reading some news from the Maharashtra, where anti-conversions law, which news says is more stringent than what the other fellow state has done earlier. So these are all has a larger impact on the Article 21 freedom issues. So while we require criminal sanctions, how far these criminal sanctions are justifiable, that's really challenging. So today's our reliance are more on the criminalizations. How we can make our laws more human? Two aspects I especially want to discuss in the morning. V. Pandey sir has already talked about one aspect, sir, which when our law itself criminalizes citizens. For example, throughout the history, length and breadth of the Indian history, there are adolescents who have sexual relationships. Now suddenly, at one go, we make every adolescent sexual relationship as criminal people. So everyone become accused of criminal. So when law criminalizes adolescent, and Brother Pandey sir was referring to about the specific case where Supreme Court has passed some remark. There are many cases, like for example, State versus Hitesh, Delhi High Court says The court held that the law should be evolved to respect adolescent autonomy and recognize consensual romantic relationships. In Sabri versus Inspector of Police, Madras High Court judgment court says that the relationship between teenagers often is stem from natural biological attractions and the legal system should not treat such individuals as criminal. In Ashik Ranjan Ansari versus State of Maharashtra, even Maharashtra case, where court says that recognizing an individual's sexual autonomy is necessary to uphold human dignity. So while it was the reactions of to a heinous crime which is a minor, but at the same time, branding every adolescent relationship as a criminal activities is definitely having a chilly effect on the impact what we see today. There is another aspect on what we see in the criminal justice systems today. And my impression is there is a large number of law where while we criminalize the perpetrator, we criminalize the victim also. I can give you several examples. For example, my area of work is on human trafficking. A large number of victims of trafficking being prosecuted under 14 Foreigners Act. When you look at the Transplantation of Human Organ and Tissues Act, under the act, those who given the organ, they is accused. Those who taken the organs, they accused. They is a trafficker. Those who are taking the organ, they are the demand creators. But at the same time, we are equating them with the victims who in the difficult situation for some reasons, they have given the organ allured by the others. So when a person who is allured by the others because of the vulnerability, we are making them also accused. In the same way, we know the cases like Dowry Prohibitions Act. Those who give dowry, those who take dowry. Both are accused. And many circumstances we say, okay, the family, girl's family who give dowry, we never prosecute them. But the facts remain, there are occasions when girl family go to the police and say, look, if you file a case, you will be also accused under the law. So law branded them as an accused. In the same way, there are several legislation. We have seen Prevention of Corruption Act. We all remember Narasimha Rao judgment, where astronomical, like I don't know how the Supreme Court at that point of time laid down that Narasimha Rao will not be liable to be prosecuted because he gets protection under Article 105 of the Constitution. But what's the result? So the result was that in that case, the persons who given the bribe can be prosecuted. The person who taken the bribe cannot be prosecuted. So the law in both the side, the victim and the perpetrator, see from both the angle. So we need to look at it. We need to look into how we can minimize and any impact which have a cascading effect on the others will definitely violate Article 21. It cannot be just, fair and reasonable as per Manika dictum.
Thank you so much, sir, for also giving the understanding to the audience that how over-criminalization violates Article 21. You have beautifully given examples also and articulated your argument. My next question is to Mr. Naved Mahmood Ahmed. Following the discussion from sir's point, can Article 21, where right to life and personal liberty serves as a substantive limit on legislative overreach in criminalization? What jurisprudence supports this or challenges this particular notion?
I hope I'm audible. Yeah. Thank you very much for the invitation to speak today. I agree that Article 21 can most certainly be used as a substantive as well as a procedural limitation on criminalization. The due process requirement does that for it, and it has been used. The court in Navtej Johar, the court in Joseph Shine, used an interpretation of Article 21 to say that life with dignity, personal autonomy are central to the right to life and personal liberty, and therefore constitutionally protected ideas. And constitutionally protected ideas cannot be criminalized. And I think that's a very clear pronouncement by the Supreme Court that Article 21 can most certainly act as both a procedural as well as a substantive limitation to the power to criminalize. The Delhi High Court, the J&K High Court have also done so in context of begging. Begging was decriminalized in Delhi, in J&K, I think both benches presided over Justice Geeta Mittal, that in a very, very simple interpretation of Article 21, that it means life with dignity. And in a context where the state is mandated to ensure that right to life is meaningful, is a life with dignity. One cannot criminalize poverty, one cannot criminalize begging. So I think in both these cases, the courts have very clearly laid the principle out. But unfortunately, the courts have also, in some instances, used 21 to uphold criminalization. And I think one of the more concerning places that they have done so is criminal defamation. Right to reputation has been read into right to life, most certainly is. Defamation is one of the reasonable restrictions imposed under Article 19 on free speech. But the Constitution nowhere says that this reasonable restriction should attract criminalization. We are one of the few countries, of course, who have continued to use the colonial framework around criminal defamation, and unfortunately, as the legislature often does, we reach out to criminal law to solve a lot of our issues. The court has also, in this case, and I think the Law Commission report also sees that criminalization is essential to uphold this reasonable restriction on Article 19, to which perhaps some reconsideration is needed. But I certainly agree with the fact that Article 21 can and is being used as a substantive limit.
Thank you so much, Naved, for giving us a few very better examples, because I remember for beggary, even the person who's denying also feeling that am I guilty of not helping somebody, and the person who gives also feels guilty because am I giving impression or enhancement to this kind of organized crime. So yes, it can, no example can be better than this example. My next question is to Professor Deepa ma'am. Ma'am, also the chief guest in the inaugural session has given reference to BNS. So, introduction to over-criminalization will not be complete if we will not take a question from BNS. The recent reform which we had in BNS indicate the expansion or rationalization of criminal law. Do you agree with this, or you can enlighten us with this, ma'am?
Hello. Okay, thank you so much. Thank you so much. So it's probably a mix of both, where you have had a rationalization. Probably in the morning speech, when he spoke of that the government had thought of Nyai as being central to the criminal justice. So probably that itself reflects that central to their interest was not, imposition of penalties or penalization, but the idea that how to deliver better justice, if I can say so. But probably, just some pointers. The simplification which has happened in terms of the language used, many of the outdated archaic terminologies, even offences have been removed. There has been the grouping of offences under different heads and elimination of redundancy of obsolete provisions of the law. That definitely indicates towards attempt towards rationalization. There has been efforts towards a victim-centric approach, which we see specifically in BNSS, where many specific provisions have been included. BNS has gone for expansion in terms of inclusion of modern day offences. So we have organized crimes coming in for the first time, terrorism, mob lynching, snatching. A very interesting thing is now in case of theft, etc., where property has gone on to include intangible property as well. So where you may probably include a sort of data as a part of it. So that also shows towards a sort of a rationalization, that's the prominent trend. However, in discussion many times what we have seen, if we say an expansion in a negative sense, for many offences there has been an enhancement in terms of punishment. So that has been a matter of immense concern, that if we wanted probably justice, if we wanted a lesser application of the custodial sentencing, because now you have community sentencing, and the same breath, if you are enhancing punishments for many of the offences, probably there may be a slight contradiction. So yes, that's why I say it's both about rationalization and about expansion to an extent.
Thank you so much, ma'am. We absolutely agree and understand that in BNS and also in BNSS, expansion matter rather than over criminalization. My next question and set of questions are deliberated to the victim-centric approach, because when we talk about, as sir has mentioned, that victim was also, become victimized for over criminalization. So the second set of question is to that. Naveed, my question is to you. How does selective enforcement based on caste, class, religion, or political affiliation undermine the normative limits of criminal law?
That's an important question. The Constitution mandates equality before law. It mandates equal protection of laws, and I think that's something that extends to criminal laws as well. And criminal laws derive their validity, derive their essence from the fact that they are offense-centric, from the fact that they are harm-centric and not person-centric. So it is critical for criminal laws to remain neutral in the way, one, they are conceptualized, in the way they are written, as well as in the way they are enforced. Unfortunately, in both these cases, we see this disparity, that they are both conceptualized to criminalize certain sections of the population, but also enforced in a way that they criminalize marginalized sections of the population. This is not something that is unique to India. This is across the country, across the world. We can see this. We've seen this in colonial governments. We've seen this by post-colonial governments. We see this in India as well. The macro picture that government data, that NCRP data gives you is very clear that members of the SC/ST community, the Muslim population, they account for the majority of the people processed by the criminal justice system. 30-35% of the under trials in the system belong to the SC/ST community. Preventive detention data gives you a very stark picture. Over 30-35% of the preventive detainees in Indian jails are Muslims. Unfortunately, in a few states, that number is touching 100%, and that is very, very concerning. Now, in our work on NDPS Act, and in fact, we carried out a study in 2018 here in Mumbai, we found that almost everybody that was charged with and convicted of offences under the NDPS Act were small-scale cannabis users from the streets of Mumbai. And this was a study of 10,669 cases, and we realized that over 95% of these people were picked up from the streets of South Mumbai. They were charged, arrested, produced before the court, convicted on the same day. And we didn't find even a single case where somebody was convicted of possession or consumption of high-value manufactured drugs that account for the most number of drugs that are seized. So who is this law targeting? Who is this person that is getting arrested and prosecuted, and who is scot-free? So I think that remains true. The second point that I highlighted was the way in which we conceptualize crimes, the way in which we conceptualize criminal offences. And I think Professor Sarfaraz rightly mentioned in the beginning that we've seen this happening in the colonial times, where laws were targeted, not criminal laws were the sole purpose of criminal law was not to solve the public order, law and order issues, but to also further the colonial administration's social, economic, and political goals, and that unfortunately has withstood the test of time and continued post post 1947 as well, and we see that even today, where criminal laws are used as instruments of social and political control. The Maharashtra cabinet yesterday clearing the anti-conversion law. We've seen laws that govern food preferences, laws that deal with civil matters, especially these laws where there is a reversal of burden of proof. Every conversion is illegal unless proved otherwise. So I think these are the cases that really I did tell you that there are concerns in the way that laws are conceptualized, laws are implemented, and like everywhere else in the world, the most marginalized communities bear the brunt of it.
Thank you so much. You have rightly discussed not only the selective enforcement-based choice, but also given rightful examples. Continuing to this, my next question is to Deepa ma'am, where we all looking at the changes in the digital world and looking at the crime rate in the digital world. And my next question is to you. In the era of digital harm, where we are talking about cyberbullying, AI-enabled crime, should criminal law expand, or should we invest more in regulatory, civil, or technological safeguards?
Okay, thank you for the question. The thing is that, see, the underlying understanding with regard to how to use and how much to use criminal law, I think that should remain the same in terms of being a law for the last resort. So not every sort of a cyber harm or cyber incident should make us, or the constant in present day where we are speaking of a lot of AI related incidences. The general understanding or the discussion I've seen is always how can criminal liability be brought about. So probably yes, where there are serious harms, when you are speaking of different cyber stalking, cyber harassment, and there may be very other serious harms included. There definitely it should be conceptualized as a crime, and the law should be developed in a way which takes it in the form of criminal liability. But the emphasis, nevertheless, should be beyond in terms of regulatory, right, in terms of technological safeguards. So I think the answer would lie there in terms of how we can do a sort of a develop sort of a more coherent regulatory regimes which can control the type of violations which are happening, as well as technological safeguards with which we can develop the technologies. But yes, in some of the specific type of cyber harms, etc., where there is a certain level of seriousness, gravity which is identified, we definitely need to look into that for the purpose of reading it within the domains of criminal law, but not our instant answer should not be for every violation. The criminal law should not be an answer. So we should be able to balance and see our responses more in the civil domain than in the criminal.
Sure, sir.
When we are saying that there is over criminalization because of nature of crimes being changing so technology, jurisprudentially, can we think that our traditional principles of criminal law, the exceptions to criminal liability, which are in the BNS, not much change from our to some circumstances, the digital divide we acknowledge. So digital divide puts our people universally, law will be applicable universally to criminal. But the technology digital divide, whether something to be done for the people who are ignorant of technology, so some type of criminal liability, whether we can jurisprudentially think on that. What is your reaction?
So I have a slightly different view. I don't think we have a crisis of criminalization because of evolving technologies. we have a crisis of over-criminalization because we can't think of ways to enforce laws other than criminal laws. There are 7,305 ways one can be prosecuted for under only union laws. This number would go up to 20, 30, 40,000 when we count for state laws as well. And 75% of these laws have nothing to do with criminal justice system. They do not involve BNSs, they are not the POCSOs of the world, they are not UAPAs, they are not all of these laws. These are laws that govern the day-to-day functioning of the society, the day-to-day of how we go about living our lives. Why should a sweeper go to jail for not informing his boss under the NDMC? There is a 3-year jail term, I think a 2 to 3 year jail term is right. Why should any one of us go to jail for missing our tax deadline? There is a mandatory minimum jail term. Why should any one of us go to jail if we are addicts of any narcotic drug and psychotropic substance? So,
In that case, it is the legislative tendency where there is a failure of the control of crime.
absolutely.
There is a tendency to have criminalized the law.
Absolutely.
That's a change, I think, particularly in our country.
And probably the easiest way, and that's also
Will you use the mic, please? Mic. Yeah. Oh. Suvarna's thing.
So it's a problem of plenty, and I think as a part of a political and a government, we always prefer to, try to get the confidence and public support through the use of the instrument of criminal law. So we think that by way of coercion, suppression, people will be much, satisfied in terms of the end result.
Sarfaraz, sir, question is to you. It might.
So I have the same view like what N. Jagati sir said. I think in the digital age, we got a new category of persons, so new kinds of illiteracy, which are technological illiterate, many times we can say, and digital illiterate, which can many times people might by mistake it happen. But then there are many such circumstances where the people who share the informations on the internet are culpable amounted to hate, culpable amounted to something wrong. So if something for giving some kinds of impunity when something accidentally or due to illiteracy happened, there is a requirement that the court can only judge. But in the cases where there is absolutely a hate, then there is a need for protection because we know where the hate can lead us. And so digital, in the digital sphere nowadays, the problem comes that in most of the legislation, somewhere it is an erosion of mens rea, and we are all adopting on the strict liability principle. So, like, it's the other party can say why they have done, whether it's done by ignorance or not, which many times proving negative will become very difficult. So, one suggestion could be what Sir has said that okay, we can have some exceptional clause in the general exception, which was there in the IPC. We have in the BNS, we brought the same thing. We have not made any changes. But in the digital age, it's required to add something more there, which can create some exceptional circumstances where something happened by mistake. Other thing for the victims, many of these digital legislations, they are more than law. It is the enforcement which can become challenging. So many circumstances, if some kinds of posts are there against the people who are in power, our enforcement agency become very super active. When something posted against the people who are not in the power, our enforcement agency does not become active. So the same circumstances, similar kinds of situation, but enforcement is completely different. And we can see state after state, we can see example, you can find those kinds of enforcement mechanisms throughout the country. So we do require somewhere to criminalize it, but at the same time some exceptions to what I believe in the many of our legislation nowadays. We have so much focus. We want severity of punishment. So you'll find the politicians comes with the idea that okay, we have increased punishment, the punishment will be more. The idea is that it's not the severity but the surety. So we require someone done, he must be punished. Whether how severe it might varies. So there are many circumstances where law says punishment of 10 years does not require 10 years punishment. If give 1 year punishment, that's also good enough. The perpetrator of wrong must know that they can be penalized, they can be punished. Many circumstances when law make in such a way which create higher punishment, the mentality comes from the court that okay, it was a can we give that much punishment to the person? Many times the law says minimum punishment. So those circumstances comes, but yes, in the detail there are
certainty of punishment.
certainty of punishment. So we require certainty of punishment, and then the digital age we require changes. So we do have come from the age of your Indian Evidence Act to Sakshya Adhiniyam. Drastic changes are there. Many changes are really for the citizen centric. Which might have some kinds of potential challenge will come for some cases we can see, but for criminal cases, at least the changes which brought by the Sakshya Adhiniyam is a potentially excellent, I can say. It gives protections to the citizens. We see how it being implemented in the future. But yes, the technology has its own implications. Technology has its own use. Many times our law does not able to fix the liability. I can give my own example. Till now, in last 4 or 5 years, every time when fictitious people make some profile in the Facebook, I send a notifications to the to make a complaint, and every single time I got response from Facebook, it does not violate our community standard. Even if the profile is of IPS officer, profile is the IS officer, so these service providers by which we spread these messages, somewhere we not able to reach them or law not able to regulate them. Those are the challenges are there.
Agreeing, sir. But yes, in coming future, we'll try to solve those challenges. With the challenges, we are now moving to the next segment, that is resolution based. After understanding the over criminalization and victim centric, now let's move to some resolution where we can look for the solution to this over criminalization. My first question in this segment is to Naved. Naved, if we could repeal one criminal provision in force today, and mind it, it's one only, significantly, not because it's unconstitutional, but because it's unnecessary or counterproductive, which would it be and why it needs to be replaced?
It's very difficult to identify one. I told, and I wish I had the time to list out 3,000 for you that should go today. And I'm hopeful that some of them will go as the government tables the Jan Vishwas bill soon. But I think one that really should go is consumption of drugs under the NDPS Act. Section 27 of the NDPS Act it was a law that we never really conceptualized. It was a law that was imposed on us in 1985, the American war on drugs. It didn't come from within. And I think it's time that we acknowledge the fact that drug addiction is a health issue. It's not a public order issue, it's not a law and order issue, it's not a national security issue. The law can be as strong and harsh as it has to be for trafficking, for peddling of drugs, for manufacture of illegal drugs. But I think we need to accommodate for the fact that there are consumers that need medical help rather than prisons. And we see this playing out on a daily basis in Punjab, we see this playing out on a daily basis across the country. And I think that time is now right for Section 27.
So I have also a question. Do you think that only substantive laws, criminalization is there, or even our procedural justice, which is our fair trial guarantee, that aspect also to look into to prevent such criminalization also?
Absolutely, I think it started with that. I think we are a country that does not need a BNS today, looking at the amount of preventive detention laws that we have. We have around 30-35 preventive detention laws in the country that cover each and every aspect of the BNS. You don't even need to prosecute anybody, you can put them in jail for on preventive basis. So I think a lot needs to be done on preventive detention, a lot needs to be done on procedural aspects to ensure that bail becomes a matter of right and not something that is discussed in conferences like these.
Business.
Yeah.
Thank you.
Now I think we can open it. Time is only 15 minutes. Sir.
Yes, last questions to both the panelists, sir.
Now we open it.
Okay, sure. As
Panelists also.
Sure, sir. We'll move to the open house discussion with this note. If the audience has any question to the panelists, please feel free. The house is yours. Please. Anybody from the audience, please raise your hand. Yes, please.
Hi, good evening everyone. I'm Ayushi. I work with the Center for Legal Policy. So overcriminalization is of course a problem. One of the very important aspects of overcriminalization is also arbitrary prescription of punishments, which is, it was addressed at some point, but even with the new BNS, we see a lot of inconsistencies in how punishments are prescribed. I would give you an example of buying a child for prostitution and selling a child for prostitution. Both have different punishments, which is 10 years and 14 years. Under the ART and Surrogacy Act, abandoning a child in one law is an imprisonment of 10 years, and in one law it's just fine. So it's just, the more you read about it, you find how absurd it is. So just wanted to understand, as of now, we don't have any clear idea of how do lawmakers decide what punishments fit the crime. So is this something that we can do about it? Sentencing guidelines for judges, of course, make sense, but it also has to flow from the law. So any comment on that?
That is very true that we do not have a policy as such. Huh? We do not have a sentencing policy, or even what we are saying should be at the level of where the judge is deciding a punishment, or even at the legislature. It has gone on by certain principles we have come across in terms of proportionality, how grave is the harm, and when it comes at the judicial level, they have many parameters in terms of who is the accused, what are the circumstances, etc. So that is something which is very important, that you need to measure, and what would be the parameters on which you would decide the perfect, even if it is not perfect, the probable punishments for that particular offense. Huh? Yes, that is what I only said, that is why you find that there has been a tendency in the BNS for those which they have identified as serious, on grounds suddenly to impose very high punishments for that. And that has been an anomaly, that where other things they have tried to normalize, rationalize, suddenly at the level of punishment, they have suddenly become very draconian. So I remember, say, Professor Pandey, I think in a previous conference, saying one step ahead and two steps back. Because somewhere you tried to bring about, we are trying to do away with the coloniality of it, and then we suddenly also become, very tough in terms of saying. But that is where we need to have a policy in terms of what would be the guidelines on which would be followed for the purpose of imposition. Like with regard to community sentencing now, Delhi has come up with certain parameters, etc. Other states are still, in the dark, trying to feature out whether to follow that Delhi thing or do something else. So that is where something, a proper work has to go to in order to how we develop ours. And something I think which is society also should have a lot to contribute on.
Thank you so much, ma'am, for the answer. I guess ma'am has rightly pinpointed the solution. We have second question, and after this, we can have one more question. That would be the last for the day.
All right. My name is Abhishek Negi. I'm an assistant professor at NLI Bhopal. So, when I was listening to the discussion of the panel, it reminded me of my student days when we were being taught that one purpose of criminal law is to protect the person from himself also. So, on one hand, we have one of the most important purpose, that is to protect the person from himself. That is why the NDPAs and these laws are there. On the other hand, now, since the panel is discussing and the reflections are that instead of treating the person right as a criminal, treat the person as a victim, because many of the people are undergoing mental trauma and stress. They are consuming the drug. So how do you balance out both the situation? On the one hand, we have the purpose of criminal law to protect, for example, wearing helmets, seat belts. On the other hand, we have the different perspective where the person who is a wrongdoer is a victim also. So how do you balance out?
I request Naved to answer this.
Yeah, I think it has the relationship. Can you hear me now? Yeah. It is fundamentally to do with the citizen-state relationship. How does the state see the citizen? Unfortunately, we continue to see citizens like we used to 150 years ago. We want to ensure that we are present in each and every aspect of that citizen's life, how they go about marriage, what they eat, and what drugs they consume, and if they don't, then we have a punishment prescribed for that. And this is what we call the paternalistic view of criminalization as well. And I think it's time for us to take a relook at this aspect of things, and it plays out very differently in different aspects. Drugs is just one issue where we feel that, learnings from the ground tell us that this is something that needs to go. But the Uttarakhand UCC tells that why does one need to register their live-in relationship? And if they don't register their live-in relationship, they go to jail. So, there are aspects like this. They need a fundamental rethinking of how the state views the citizen. And I think that is where the solution really lies.
To add one just sentence, but Naveen has said that sometimes it is not to look into our criminal law to protect individual. It is the social order we have to see. That's why I think sometimes this discrimination or sometimes you see spiritual distress, individual suffering coming up. But overall, criminal law should try to uphold the social order. Particularly this offense you are talking, these are known as public order crime, where people at large to consider more than individual. I think that may be the reason behind this happening.
And I think the move is actually happening. If you look at the past 6-7 years of legislative developments at the union level, starting with the enactment of the amendment to the Companies Act, the LLP Act, the thrust that we need to do, be trust-based and not focus on punishments. Then movement towards courts decriminalizing adultery, decriminalizing homosexuality. Then the government again with the Jan Vishwas one pushing the agenda of trust-based governance over punishments and focus on deterrence and forcing people to do things. And I think that is where the real mindset change is happening. It might today be happening because of ease of doing business, but tomorrow it will certainly happen because of ease of living. And I think that's where the role of the civil society comes in, to really identify and pinpoint these issues so that it becomes a part of a larger reform effort. But I really think that the movement at the union level and across states has really now gained momentum.
My question is, the panel theme is, do we need limits on criminal law? The statement underscores that there are some limitations. Are there any limitation? Can it be imposed? Does the plenary power of the legislation has some limitation? And if at all there are limitations, are these limitations normative? Are these limitations constitutional? Because if we put constitutional guardrails, under constitution the logic is also security, as is liberty, and any law could be justified on the ground of security. Sir mentioned about
Protection also.
public order, reasonable restrictions also. Should we find it in philosophy or the normative theories? And if yes, which theory of criminalization then we should adopt? Thank you.
theory, what principles of criminal law to limit. I think the limitation is we have this balance of interest which our sociological thinkers, when we are making a law, we know that there are some constitutional things that discriminatory justice, affirmative action, or undiscriminative justice. But overall, we have actually balancing some interest also. That's why question of sanction in our corporate law, increasing in when particularly corporate fraud, the total cost of property offences and total cost of corporate offences. The whole country, the property offences and the only corporate offences, corporate fraud, 4 times the property offences. So we have to think the social conditions also, that what is happening, what are the changes, social conditions, that also, because it is not that law will static. According to situation, sometimes the punishment or sanction by sometimes public opinion, sometimes the government policy, sometimes even the government treaty obligations make the changes of this punishment or criminalization. These are sometimes also the government policy influenced by globalization or treaty obligation. These are things happening in our criminal jurisdiction.
Good evening, everyone. My name is Garima Agrawal, and I am from National Forensic Sciences University, currently pursuing MA in Criminology first year. So my question is, as someone who is currently pursuing and studying about this field, we have been taught about many previous laws and the laws which are still currently in force, like as you mentioned NTPS 1935 and all. Those are still in force, but obviously there is a generational gap between that time when the law was enforced and now. So I would like to know your thoughts upon it.
Absolutely. I mean, these laws have to be re-examined and these laws have to be updated to match the social, political, economic realities of today. And NDPS is just one example. But we have never as a society been fully in sync with the NDPS Act. But as a society, we've also evolved. Things have changed. The Supreme Court strikes things down, responding to the social morality, to the changing social morality. The Parliament enacts laws in response to the changing social morality. Whether it's in the right direction or the wrong direction is something that we can look at on individual basis, but things are changing. And as I said, with the decriminalization effort at the union level and state level, and I think there is a concerted effort to do that, and I think it's in the right direction. But I would like to go back to Chirag's question on limits to criminal law. I mean, you're the best person to talk about this. You've done a lot of work on this, Chirag. But there are limitations to criminal law. I mean, these are limitations that the courts have used to strike down adultery, have used to strike down homosexuality. These are limitations that the Company Law Reform Committee used to decriminalize offences under the Companies Act. These are limitations that the government today is using. There are a set of principles that the government today is using to decriminalize offences under hundreds of laws, I mean, that they are examining across the country. So the limitations are fundamentally based on the idea of harm, the harm principle, it could be the proportionality principle, it could be other ideas. The question is, how do we integrate this into our lawmaking process? And because today we will end up decriminalizing a lot, but what is preventing the government from going back to where we are? What is preventing the government from decriminalizing holding of a national conference on criminology? Nothing. We can challenge it in court. We can say, oh, this is unconstitutional. The court will strike it down in a year, 2 years, 5 years, whenever it pleases. But nothing prevents the government from doing it. And we perhaps need to conceptualize that, whether there are constitutional limitations, whether we need statutory limitations, whether we need impact assessments that are a part of a pre-legislative process that allow us to do so. So I think that is where a lot of thinking needs to happen. Whether we can bind the parliament with a particular theory that all of us academics are appreciate or engage with, I am not so sure, because I mean the Parliament, of course, is responding to what the public demands are, how the society evolves. So we may not be able to bind it, but we certainly can, provide some principled basis to criminalization, and I think that will go a long way.
To the concluding remarks that as Siraj also raised, that whether there is really limit of criminal law or criminalization, I will bring as young student who are raising the question. I am referring the 2 years back perhaps the NEET scam and the consequent law on Public Examination Control and Prohibition Act. But sometimes the incident in a society, criminalization, we have our laws, that time the issue also, that is not sufficient. Immediately government within 2 months legislation criminalizing some scam relating to public examinations. So criminalization limit is there, but it is open also that legislation and legislature, supreme legislature to control the society can adopt the principle of criminalization even if there are limits in matters of criminalizing and imposing punishment to citizens. So I think with these words our time is over. Within 1 hour we completed. Thank you all.
Please give a big round of applause to the panel. With this, I thank each one of you for answering rightly and appropriately the questions and also taking audience questions. Thank you so much, everyone, for this discussion over this topic. Thank you. Thank you, everyone. I request Professor Dr. Parma Akshay Malviya, Director of School of Law, and Professor Dr. B. Madhava Somasundaram, Chairperson of the ISC, to kindly step forward and felicitate the resource persons who will be with us throughout this 3-day conference. I request L.K. Chakravarti sir to kindly step forward. I request the dignitaries to felicitate Dr. D. Rufus, Assistant Professor, Dr. Ananta Ramakrishnan, Assistant Professor, give a huge round of applause. Mr. T. Jose Benjamin, doctoral candidate. Dr. Rupesh Upadhyay, Assistant Registrar. Professor Dr. B. Pandey, Professor of Law. Professor Dr. Balraj Chauhan, sir. Professor Dr. Mehrajuddin Mir, sir. Dr. Meenakshi Sinha. Dr. N. P. Alan Selvakumar, Secretary of ISC. Professor Deepa Dubey. Abhishek Negi sir. Arjita Mukherjee, Assistant Professor. Dr. Sarfaraz Ahmed Khan, Professor. Dr. Kavita Singh. Dr. Surja Kanta. Dr. Murugeshan. Dr. Divakar Singh Rajput. Dr. Beulah Shekhar. Dr. Naftika Singh Nautiyal. Dr. Anand D. Chinchure. Professor Dr. Devrati Haldar. Anil Variat sir. Dr. Raju Narayan Swami sir. Professor Dr. Arvind Tiwari. Dr. Rajashri Varadi ma'am. Dr. Kavita Rajchandani ma'am. Mr. Naveed Mahmood Ahmed sir. Ayushi Sharma. Professor Ruchi Sinha. Dr. Hani. Dr. Karuna. From RRU. Dr. Swikar Lama. Thank you, dignitaries. Please gather for the technical session at the second, for your respective rooms.
So, those people who have paper presentations and those who are chairing the paper presentations, go to the allocated room. Other experts, please join us on the second floor boardroom for the roundtable discussion. On the second floor boardroom. Our student volunteers will guide you.